Arizona's highest court. We'd like to thank Page High School for hosting us this morning. If you could kindly give them a round of applause for doing a great job in hosting us. Oral arguments are official court proceedings of the Arizona Supreme Court. So we'll ask you to follow court decorum just as if it were being held in Phoenix at the courtroom. At 9:30 a.m. in approximately 5 minutes, the clerk will strike the gavel and all attendees should stand as the justices of the court enter. Once they sit, we can all sit. I'd also ask that you take out your cell phones to make sure that they are put on silent. Please maintain a respectful and quiet demeanor during oral arguments. Questions, interruptions, or other actions that can distract from the arguments are not permitted. Taking photos or video also is not permitted during arguments, and we ask again that you put all your devices on silent. We also ask that you do not take phone calls during oral arguments. At the end of oral arguments, there will be a question and answer session with students and those members of the public who wish to ask the court questions. We simply ask that you do not ask questions about the proceedings that you're about to see. Once question and answer begins, we will have a microphone at the foot of the stage, so please make your way down there once question and answers begin, and we'll get you assigned accordingly. Thank you so much, and we look forward to oral arguments here in Page, Arizona in about 5 minutes. Thank you.
If you're planning on all getting together, why stay in hotel rooms and not be together?
Final test. How do we sound on Vimeo?
Please be seated. Well, good morning. We are so pleased to be here for oral argument, Page High School, in front of the Sand Devils. So we will get right to it and call the first case, which is Markham versus Cahava. It's our number CV-25-0036. First thing, both counsel are very experienced and they know this, but I'll say it anyway. Each side has 20 minutes. There is a clock at the podium for that purpose, that you can keep your time. Mr. Berg, you can reserve whatever time you wish for rebuttal, but you'll have to keep your time yourself. For my colleagues, please remember to hit the microphone button if you'd like to ask a question, and then turn it off when you're done, because my experience is you get a lot of feedback if there's multiple devices on. So with that, Mr. Berg, please proceed.
May it please the court. Timothy Berg of Fenimore on behalf of defendant property owners. I would like to reserve 4 minutes for rebuttal. Under well-established law in this state, a property owner is not liable to a contractor in unjust enrichment for benefits received under a contract with a third party to which the property owner is not a party, unless the property owner has engaged in improper conduct. As the Court of Appeals in Wang noted, when a non-owner contracts for improvements to the owner's property and then fails to pay, the owner is not liable to the contractor or the supplier unless he agreed to pay them or engaged in improper conduct. That is because the doctrine of unjust enrichment requires unjust enrichment, not just enrichment. Responding to Markham's claim here that the property owner's interaction with the district is enough to be improper conduct, I direct the court to the Wang opinion, where the landlord in that case required the tenant to make improvements, proved the improvements, agreed to pay for part of the improvements and paid for part of what he agreed to pay for, but not all of it. None of that was sufficient to show improper conduct in Wang, and what the Markham has alleged here is not sufficient to show improper conduct. If you look at the Amiski's argument, they seem to argue for a broader view of unjust enrichment, which is simply knowing that you're going to receive benefits and keeping them is enough. Again, clearly that's inconsistent with Wang and a number of cases of this court where it isn't enough. Plaintiffs needed to allege improper conduct, and they didn't do so. First point I want to address is whether Wang is limited to the landlord-tenant context. It is not. If you read the opinion carefully, it is not limited to
Mr. Berg, I have a question for you. On page 6 of the Markham supplemental brief, he says that your client is asking this court to make Arizona an outlier, becoming the first court anywhere to make an allegation of improper conduct a necessary condition to stating an unjust enrichment claim outside the tenant improvement context.
Your Honor,
Wait, is that a correct statement?
No, it is not, Your Honor. We cited in I believe in our response to petition for review, and perhaps in our supplemental brief, and I know in our briefs in the Court of Appeals, other cases which have applied the improper conduct or have basically applied Wang outside of the landlord-tenant context.
And I'm sorry, Mr. Berg, where did you say that was cited in your briefing?
I don't have my appellate brief with me. I know the cases are cited in either our supplemental brief or in our response, and if they're not, I'm happy to send the court a citation from our answering brief in the Court of Appeals after the argument.
Thank you. Mr. Berg, you said that Wang, if you read it carefully, didn't limit its holding to landlord-tenant situations. And it didn't. It did not say that in truth. It relied on that DCB case from Colorado, which did say it was limited to landlord-tenant, and then later the Little case at the Colorado Supreme Court said, yes, this is limited to landlord-tenant. I'm more interested, though, in why shouldn't it be limited to landlord-tenant situations?
Let me answer that question in two parts. First, Your Honor, as Your Honor well knows, the Wang opinion cites restatement first of Restitution 110, which states a broader principle of restitution outside of the landlord-tenant context. So it seems to me that the restatement is a sufficient answer. Basically, the restatement says, a person who's conferred a benefit on another as the performance of a contract with a third person is not entitled to restitution from the other merely because of failure of performance by the third person. There's nothing about that that limits it to the landlord-tenant context. I think the Wang rule is properly applied in any situation where, whether it's landlord-tenant or otherwise, a contractor provides goods or services to a party due to a contract with a third party. The recipient hasn't signed a contract and hasn't engaged in improper conduct. There are undoubtedly other kinds of restitution claims that it might not apply to. But I think it clearly applies under the restatement to the sort of, I'll call it the three-corner unjust enrichment, where you have a contractor, a person with whom they've contracted, and a different person who receives the benefit but hasn't agreed to pay for it and hasn't engaged in improper conduct.
Counsel, may I ask you a question?
Absolutely, Your Honor.
With respect to wanting us to adopt Wang, I know the Court of Appeals referred to it as this court's case, but it's not. It's a Court of Appeals case. First, I haven't heard a good argument about why we should adopt it. And secondly, so if you would address that. And then secondly, the argument that there should be improper conduct element for unjust enrichment claims seems to create a per se rule when unjust enrichment causes of action in general require courts to look at the particular facts and circumstances of the unjust enrichment. So one, why should we adopt Wang? And secondly, it seems like, and if it's not, please address it, that you're advocating for a per se rule that would modify how unjust enrichment claims are reviewed.
Let me start with answering your second question first, because it relates, I think, to the answer I just gave. We're not saying in every case of unjust enrichment, there needs to be an improper conduct element. What we're saying is if you have a transaction like this, like the restatement talks about, where you have his client contracting with the district, building infrastructure which they allege benefits my client, which, because this is a motion to dismiss, we have to accept, that because my client doesn't have a contract with them, they don't have a claim against us unless we've done something improper. And as then Judge Timmer pointed out in the Wang case, what makes the enrichment unjust here, you have to have some unjust action by the recipient to make it unjust enrichment. And what it takes to make unjust enrichment happen here is some kind of improper conduct, misleading conduct, fraud by the recipient to make it appropriate as a remedy against the recipient.
Why couldn't it be? I mean, here I'm taken by the fact that, if I understand the facts correctly, that this group of owners wanted to make improvements in their community, and so they formed the district. A number of them sit on that district board, and the idea was that the district would then engage and contract with folks who would give this infrastructure and make the community better. And the idea was there would be bonds and there would be assessments and they would pay for it. And then the district did not do so, did not make the payment. In that scenario, even if we went under the improper conduct, the Wang kind of thing analysis, why wouldn't this be improper and certainly unjust not to have these folks be on the hook for the improvements to their property and their community that they intended occur?
First of all, Your Honor, let's start with the fact that the revitalization district requires that property owners be on the board. If you look at the statute, a non-property owner cannot be a director of a revitalization district. So there's always going to be identity between the property owners and the district. If you follow their argument to the end, which is by virtue of being on the board, the property owners give away their separate entity, there's no separation between the district, and that's inconsistent with long Arizona law saying a district is a separate entity from the property in it or its members. And two, you essentially ignore the fact that all Markham had to do here, if it wanted to, was get guarantees from the property owners. It chose to contract only with the district and leave itself without a remedy against the property owners. And that is a choice they made, and it is a choice they should live with. I want to go back briefly to part of Justice Montgomery's question. I apologize that I didn't answer. Why should you adopt Wang? Because one, it follows Arizona law as recited in the case, relies on the restatement. It creates, if you adopt the rule they're asking for, you're limiting, you're saddling, non-contracting parties with contractual obligations they didn't choose to agree to. And it's a basic principle of contract law that if somebody wants to sue me for breach of contract or a claim based on a contract, we ought to have a contract, and they oughtn't be able to reach out and grab me if I'm not a party to the contract. What you're doing is interfering with both the operation of the revitalization district law and with basic contract law if you say that somebody who's not a contracting party can be held liable under these circumstances. That's why you ought to adopt Wang, Justice Montgomery.
Follow-up question to the Chief's question. How is the district formed? Don't the owners play a key role in forming the district to obtain improvements?
The owners certainly play a role. You cannot have a district without the property owners agreeing. Absolutely, Your Honor. And you create the district because you're planning on making improvements, and you're doing it for the benefit of the people, maybe the people who are on the board, but it may also benefit other property owners who are within the boundaries of the district. May end up, in this case, benefiting the municipality that the district is located in. But absolutely, the whole legislative scheme here of revitalization districts contemplates that it is the property owners who will create the district. property owners who will be the board, but that the district isn't property owners. There's a separate legal entity, and they have not alleged a case for, I guess you could call it piercing the district veil instead of piercing the corporate veil, to go behind the district and challenge.
But the property owners informing the district consent to assessments to pay for the improvements, correct?
They do, Your Honor.
Now, Wang cited Blue Ridge, and you've cited that case in your briefing as well. I go back and I look at Blue Ridge, and it seemed to me that the dispositive factor in creating the principle that Wang cited Blue Ridge for, which is that unjust enrichment should not saddle entities with expenses they chose not to incur. In Blue Ridge, the dispositive fact seemed to be that the owners did not do precisely or analogously what the owners here did, which is vote to form a district to then encumber them with the responsibility to pay for improvements ultimately.
Your Honor, I guess I would say the principle is broader than the specific facts in Blue Ridge. I agree with you, in Blue Ridge there wasn't an election, so the district wasn't properly created. But I think the idea of saddling a third party, the landlord in Wang, property owners here, with an obligation they did not undertake is broader than just the facts of the Blue Ridge case. That would be my answer.
Mr. Berg, you've referenced the statutory scheme, and there was some discussion in the briefing about, if we rule in favor of Markham, it will undercut the policy reasons behind the statutory scheme in the first place. What do we make of the fact, though, that the special taxing district, that the statutory scheme does not insulate the landowners from liability? I didn't see anything in there that would carve out or insulate the landowners from liability in this type of context. What do we make of that point?
I don't think the district statutes deal with unjust enrichment claims against property owners. I would agree with you, Your Honor. I don't think there was a reason to. What they did was create a district, and they said the district could contract with someone like Markham to have improvements, and Markham has a claim against the district, again, having chosen not to get guarantees or some kind of arrangement with the property owners. At that point, they have a judgment against the district already. At one point, they have or had a claim for mandamus against the district to compel it to make assessments. Those are their remedies. Their remedies are against the district, not against the individual property owners who aren't parties to the contract. You are stretching unjust enrichment too far. You're using it to create contractual relations that don't exist.
Counsel, you mentioned earlier, back on the unjust enrichment point, that there has to be some sort of injustice. And so you don't dispute that the improvements were made. And if you don't, then on what basis can you argue that it is not unjust for your clients to retain those benefits without payment?
First, Your Honor, I would point you in Wang. Again, the improvements were made. The landlord had the property back. The court held that just getting the property back wasn't unjust, wasn't improper conduct, including property back with the improvements, pardon me. And the same is true here. What it requires is something more than simply the creation of infrastructure that may benefit my clients. It requires, under Wang and under the restatement, something more than merely the fact that we received the benefit. I believe I read the restatement to you. If you look at restatement 110 of the first restatement of restitution, it's clear that simply receiving the benefit isn't unjust merely because the other party doesn't pay. That's the basic principle of restitution. And if that's all there is here, Your Honor, then they don't have an unjust enrichment claim.
Do you dispute that there was a benefit to the homeowners?
I believe because this is a motion to dismiss, Your Honor, I am not permitted to argue that it isn't a benefit or that it wasn't to the homeowners. They pled what they pled. But I don't think under the existing law of this state, under the restatement, simply the fact that they didn't get paid by the district is enough, particularly when they have a judgment against the district and they at least thought at one point they had a mandamus remedy.
So your position is that whether the improvement was a benefit or not is immaterial.
Yes, Your Honor, that's my position, because I think that's what the restatement says.
I know you're at the 4-minute mark, but quick question. You've mentioned restatement section 110 several times. Does restatement section 25 have any applicability?
I don't have that in front of me, Your Honor, so I don't have an answer to that question.
Great.
I think I looked at it and concluded that it did not. That in this situation, while the broader principle stated in Statement 25 says what it says, and I'm doing this from memory from a couple days ago, but the specific restatement provision that applies here is 110, because this situation is exactly like Wayne.
Thank you.
And I'll save the rest of my time for rebuttal if I might. Thank you.
Thank you. Mr. Fraser.
Good morning, Your Honors. May it please the Court. My name is Eric Fraser. I represent Markham Contracting. I'd like to jump in with Justice Bean's very first question about cases that require improper conduct outside the tenant improvement district, or outside the tenant improvement context. What Mr. Berg, I think, was referring to is cases that cite Wang for other propositions. There is not a single case that requires improper conduct outside the tenant improvement context anywhere. And if this court did that, it would be the first. The question before the court is whether improper conduct is required outside that context. But again, every jurisdiction that requires it does so only in the tenant improvement context. That's how Wang articulated both the issue in the case and the holding. That's how the Colorado Supreme Court has clarified its own holding. The Lewis v. Lewis case made that explicit, that it's an exception, it's a narrow exception limited to this particular context. And that's how the Court of Appeals has interpreted its own opinion in Wang, not only in this case below, but also in the Beecham versus Gust Rosenfeld case. Requiring improper conduct in every case would make Arizona an extreme outlier, and it's incompatible with the basic premise of unjust enrichment, because unjust enrichment is not about wrongdoing at all. The fundamental basis, as Justice Cruz identified, is about benefits. It's not about wrongdoing. It's not about malfeasance. It's not about improper conduct. It is not a tort. And we can't import tort principles into unjust enrichment, because you can have an unjust enrichment claim with a completely blameless, innocent defendant. The classic example of this from law school is you have a boat tied up at a dock and there's a storm, and a bystander sees the boat is about to drift away and takes action to save the boat. The defendant there did nothing wrong. The defendant would be the boat owner, of course. The boat owner did nothing wrong. The defendant was blameless. And yet the bystander has an unjust enrichment claim against the boat owner for those services rendered. You do not need any kind of wrongdoing by the defendant to have an improper conduct claim.
Let me ask you this, Mr. Fraser, because this kind of scenario, the way I view these kind of districts, are very similar to a municipality. So say the city of Page, since we're here, decides to develop the community by putting in a park system, or a new park system, I assume they have them, parks, and develop it, and then they renege and don't pay the contractor for putting that in. But everybody agrees that their land values go up and they're benefited and they've reaped that. Does the contractor have a claim against homeowners that have benefited from their city putting in parks?
Your Honor, almost certainly not. Obviously, benefit is one element of the claim. It's not sufficient. In your example, obviously you didn't have facts like the every single resident of the city of Page agreeing in writing that those improvements would benefit their property. Every single resident of the city of Page agreeing to fund those improvements via a specific mechanism. You don't have every single resident of the city of Page authorizing Page to hire a contractor to do that specific work.
So where do we draw the line? I mean, what I'm obviously interested in, because I agree that they couldn't hold the people in Page for that individually, where's the line drawn? If it's not improper conduct, it seems like you have to have some type of, from what you're saying, some kind of active conduct at least, not a passive person who happens to be benefited from some decisions made by others in a contract. when we're done, obviously, for people here, we're going to write an opinion to describe all this and give guidance for the future. How do we write it then? Where is the line drawn between the City of Page resident example and then what you've said or maybe the Wang example of improper conduct?
Your Honor, first of all, I think you should respectfully resist the temptation to draw really bright lines in this area because unjust enrichment is a flexible, equitable doctrine. It is meant to kind of catch the unusual facts that where the ordinary contract law and tort law doesn't address. To answer your question in particular, I think Restatement 3rd, Section 25 provides the right tools here. It is a multi-factor test that looks at principally whether this would create a forced exchange. The forced exchange principle is key here. You don't want to subject someone to liability that they thought they would be free from. And so the third restatement goes through and it asks, did the defendant express a willingness to pay? In your Page example, they did not. And so you just have you go through those factors. I think that's the right test to adopt. Or if you don't want to adopt that formally, again, you can say that in these facts where you have people agreeing in writing that the district can sign a construction contract, agreeing in writing for the particular work to be done, that is enough. And future cases can try to sort between legitimate cases and illegitimate ones, like we do ordinarily in the common law for equitable doctrines.
What about the fact that you say, well, they agreed to pay for this, but they didn't agree to pay for it individually, the entire amount. My understanding was raising bonds and such, so they maybe had agreed, I thought, to take a part of it, and maybe this is going beyond the motion dismiss stage, but just humor me, I suppose. Is someone in that scenario, under your argument, then on the hook for the entirety of the cost when they maybe had kind of signed up for having a particular percentage through an assessment?
So let me answer your question in a couple of parts, Your Honor. The answer is if somebody only agreed to pay up to a particular amount, then the doctrine can limit the liability to that amount. I think that's the AM leasing case where there was a contract to rent a crane and then the crane went over and so on. But in this case, on a motion to dismiss, the question is whether Markham's claim can proceed at all. And so there is a claim here. There's a claim that can proceed. The parties can fight over the scope of the remedy and so on. I think in this case, I don't think it's disputed that these defendants would be on the hook for everything. I haven't seen any dispute about that. The assessments were designed to fund everything. So the assessments were designed to fund the whole kit and caboodle. The bonds were used as kind of a way to float that money for a while, and the assessments would be used to repay the bonds and repay the contractors. So in this case, these defendants agreed to pay everything. And the question I think that is at the bottom of what you're asking about is this, again, this forced exchange concept. Mr. Berg has talked a lot in the briefs and at the argument about you don't want to saddle someone with contractual obligations when they aren't the direct counterparty. This concept of a forced exchange means something really specific in the unjust enrichment context. We're not in contract land. A forced exchange means this. It means if an out-of-work landscaper drives by my house and trims my trees without asking me and then rings the doorbell demanding payment, I can say, no, that violates my rights of choice. I never asked anybody to trim my trees, okay? That would be a forced exchange. But if I ask my landscaper to trim my trees and he says, well, and we agree on a price and I agree to pay him, and then he comes out the next week and says, oh, there's a really tall palm tree. I'm not climbing up that thing, but I know a guy who's going to climb up the tall palm tree and trim it. And then I don't pay the landscaper. I don't pay anybody. That palm tree trimmer has an unjust enrichment claim against me. Even though I didn't hire him, I don't have a contract with him because I chose to have my trees trimmed. I made the choice to have my trees trimmed. And so he has a claim against me, not in contract, but in unjust enrichment. That's what we have here. These defendants chose to have this work done. They explicitly chose it. The facts almost couldn't be better, that they have in the contract that they agree this work will benefit their property by at least the amount of the assessments, which is what they agreed to pay. So if they chose this work to be done, that is not a forced exchange. It does not violate their rights of choice.
Getting back to the Chief's question on that very point, you emphasized here a verb, chose, which is an actus reus. And I'm struggling with the same thing as the chief, which is, and I agree that the forced exchange is a backstop in this context, but I'm not sure whether it's an adequate backstop to protect the truly innocent bystander. And the concept that has come through into my mind throughout this case and this issue is estoppel. And that is that you've done something to bring yourself into an obligation. And it strikes me that even if improper conduct, which I don't even know what improper conduct means, but if improper conduct is not the general actus reus that's required, I would feel a lot better if I knew there was some sort of actus reus.
So the easy one in this particular context of a contractor and a landowner is the flooring systems rule, which is if you agree to pay somebody, if you agree to pay an intermediary, and you didn't pay that intermediary, I don't think anyone should have any qualms about forcing you to pay when you didn't pay anybody. You reneged on your agreement with the intermediary. And that's what we have here. The district is an intermediary. And in the construction context, we have all sorts of different types of intermediaries. You have general contractors serving as an intermediary between the owner and the worker. You have designers, architects, engineers, or here you have a district where owners get together and they hire and they have an intermediary between the owners and the contractor. The flooring systems rule is on all fours. If you don't pay the intermediary, I think that's enough of an actus reus that I think we shouldn't have any heartburn about this. But again, I want to be super clear here that unjust enrichment does not require wrongdoing by the defendant. And that's the boat example where the defendant did nothing wrong. The Murdoch-Bryant court emphasized this point. The third restatement emphasizes this point. Unjust enrichment is not about fault, and it doesn't require wrongdoing. The defendants have emphasized Restatement 110 over and over again as a basis for requiring improper conduct. 110 does not mention improper conduct at all. So 110 cannot support an improper conduct requirement for all cases. It doesn't even mention it. And nothing goes as far as the defendants, I think, want you to go, which is to say that in this category of cases where you have an intermediary and you don't have a direct contractual relationship between the worker and the owner, that there's no claim. No, Wang doesn't go that far. The restatement doesn't go that far. If that were the rule in Wang would not have required improper conduct. You would just say, no, you don't have a direct contractual relationship, so you're out of here. But Wang says the claim can proceed if you have improper conduct. In our view, that's too narrow of a rule. The first restatement doesn't require improper conduct, and it doesn't preclude the claim.
Pause here. Let me take you in an entirely different direction. Correct me if I'm wrong about my factual premise here. I think that you asked for attorney's fees based solely on the provision of arising out of contract. But your entire argument, or a major part of your argument, is there is no contract binding your clients here. Am I right about that? And if so, Flooring Systems holds that this unjust enrichment action arises out of law and not out of contract. And I think that's also thematic of your argument.
Right. So I think the 12-340-101 doctrine is a little bit muddied, and there are cases that essentially say that if the contract is the factual predicate that brought the parties together, even if they don't have a direct contractual relationship, that can be sufficient. I don't have the case name off the top of my head. I think it might be Ramsey Air Systems, but I might be wrong about that. I think in this case, I think the better course would be to reserve attorney's fees until the end of the case. We can determine exactly what the basis of the claim was that was successful. I don't think you need to resolve the attorney's fees issue right now in this posture on the petition for review. I don't want to retrod ground that I've already covered, but the defendant's argument really is that a contractor can't leapfrog over an intermediary. Again, that is not an accurate premise, not an accurate statement of Arizona law. Flooring Systems allows that. Wing does not preclude that. The first restatement doesn't preclude that. Murdoch Bryant and Costanza Flooring Systems are all in that posture where you essentially have what the defendants are calling leapfrogging. You have an intermediary between the defendant and the contractor. All of those authorities at least allow the claim to proceed. They may require certain other things like improper conduct.
You address the point Mr. Berg made. I do have concerns about this. That's why I was on trying to do a little line drawing here. Generally, by analogy, we look at a corporate structure is a corporate structure, and you're not going to get the individuals that are the shareholders and such. And I kind of looked at it the same way. You have a district that's taking this on, and you all apparently did not ask for guarantees to bring in the non-contracting parties to put some liability on them. So could you address that? Should there be, why not? Why not leave the protection of they have formed a district to do this and you're now reaching non-contracting parties or trying to effectively do what you didn't do, which is get a guarantee?
Right. So first of all, Your Honor, I think that same argument could be made in literally all of these unjust enrichment claims in this posture. Flooring Systems, Costanzo, Murdoch Bryant, you could say the exact same thing in all of those cases, that the parties could have structured their deal differently. And I think the key point here is we're not trying to hold the owners liable because they formed the district, right? We are saying that they are liable because they received a benefit, and it would be unjust to allow them to keep that benefit. We're not trying to pierce the corporate veil. We don't need alter ego here. We're not trying to say that the district's actions are themselves actions of the owners. What we are saying is that those facts that the owners agreed that this property would, or that these improvements would benefit their property, that allows us to satisfy the required element in an unjust enrichment claim that they were benefited. That the fact that they agreed to pay for these improvements through the assessments satisfies the unjust enrichment requirement that they did not expect to be free from this burden.
And
So,
would it be that, I'm sorry to interrupt, but your time's dwindling down, but so you've got an arbitration award already against the district. So in filing this, as I understand it, and I understand you're saying is you're not trying to pierce any veils or anything like that, that if you proceed on your case, it would be couldn't say, we want you to be responsible for the judgment that's already been adjudicated. Instead, it's a do-over from that standpoint, where the owners and Markham can litigate what's the value of the benefit that was conferred, I suppose, on each owner, and try to evaluate, which might not equate to the contract price and the arbitration award that you have. Is that how you see it?
correct, Your Honor. This is not like a collection action on that existing judgment. That would have to be adjudicated, which I think is why some of the arguments that the defendants make are premature about trying to saddle these particular defendants with more than their fair share. Those are things that would be litigated after the case proceeds. That's for the superior court to resolve in terms of remedies and in terms of proof and so on. That is not a reason to dismiss the case at the outset, which is what they're trying to get you to do, is to rule that Markham's claim cannot proceed at all.
Mr. Frazier, I wanted to ask you about the statutory scheme, which I asked about earlier. There was a lot of discussion, or at least some discussion in the briefing about if we rule in your favor and we eliminate some sort of improper conduct requirement, that it will undermine the fundamental purpose of the statutory scheme that the legislature enacted, which we can't overlook that point, of course, but I was hoping you could respond to that. If we eliminate or if we find that the improper conduct requirement is not required in this circumstance, does that not do some harm to the statutory scheme? Could you just respond to that point?
It does not, Your Honor, and here's why. First of all, one thing that you can take away from the statutory scheme is that the property owners are expected to pay for this work. That's in ARS 386808A11. It's in 486815. The property owners are expected to pay for the work. So requiring them to pay for the work does not undermine the statutory scheme. The statutory scheme obviously does not have any exemptions from the common law or any immunity from unjust enrichment claims. The other thing that I think is important to note is what will undermine the statutory scheme is not paying the contractors, because what contractor is ever going to want to work on a revitalization district if the revitalization district can decide just not to levy the assessments and then not pay the contractors? What bondholders, what financing companies will ever agree to fund bonds when the bonds get defaulted on and the assessments never get levied? Allowing the unjust enrichment claim to proceed here, I think, preserves revitalization districts and allows them to operate in the future, because people will actually do business with them if they know they'll get paid. What the owners did here is not pay their bondholders, not pay their contractors, and not levy the assessments that they were supposed to levy under their agreements and under the law. Again, requiring improper conduct in every case would make Arizona an outlier, and so we ask that you affirm the Court of Appeals, reverse the Superior Court, and remand to allow the claim to proceed. Thank you.
Thank you, Mr. Fraser. Mr. Berg.
Mr. Fraser asks you, what contractor would contract with the district? Someone who thought the district was financially sound and already had enough money? Someone who said, well, I'm concerned about the district, so I'll go get guarantees from the property owners. That's how this scheme is supposed to work. The court asked, where should we draw the line here? You have to draw the line. As the Chief Justice pointed out, as Mr. Fraser agreed, if the city of Phoenix improves 24th Street and decides for some reason not to pay the contractor, people who own property along 24th Street shouldn't be responsible for that, just like people here in Page shouldn't be responsible. What is the line you draw? The line in a case like this is improper conduct or direct involvement of the benefited party by contract or otherwise with the contractor that's making the claim. You've got to cabin this in some way. Mr. Fraser says, don't worry about it. We'll work it out on the facts of the individual case. Unjust enrichment is flexible. It ought to be this all-encompassing remedy that can do whatever the court thinks is good in any particular set of circumstances. That's wrong. The reason the Restatement 110 says what it does, which is that his client doesn't have a claim against my client merely because the district didn't pay them, is to cabin unjust enrichment in that particular circumstance. You have to have a limiting principle. And the principle that the Court of Appeals adopted in Wang is the correct one. If, unlike Flooring Systems and Costanzo, the property owners aren't directly involved in soliciting the bid from these folks or agreeing otherwise to pay them, then you need improper conduct. And you don't have that. If you don't cabin this in some ways, the doctrine becomes all-encompassing. It isn't our position that you need improper conduct in every case of unjust enrichment. Again, there may well be claims involving things other than the kind of contracts that are covered by Section 110 and that may not fall outside the improper conduct. Justice Bullock said he doesn't know what improper conduct is. Improper conduct is fraud, misleading behavior, that sort of thing. It takes some sort of involvement by the recipient that is wrongful, something other than taking advantage, something other than taking the property that's been given to them or built there.
Any authority you can point to that would define that?
I think the best I can do is tell you to look at Wang, because Wang talks about what improper behavior is and gives at least one or two examples. I'm not sure. We did go out and look for an additional authorities that define that. I'm sorry, Your Honor. Really, unless the court has other questions, that's all I have. Please reverse the opinion of the Court of Appeals, affirm the opinion of the Superior Court, and let Markham go out and collect from the district, either by collection or by mandamus. Thank you.
Thank you, Mr. Berg. All right, thanks to to both counsel for your arguments and your briefing in the matter. We'll take it under advisement and issue an opinion in due course. We are going to stay on the bench and give a few minutes for the technical switchover on the recording system and allow the next parties to come forward. For counsel here, a couple of things. One, after we're done with the next set of the next argument, we're going to stay for question and answer. You're welcome to stay. You're welcome to answer questions. But if you're also welcome to leave, I wanted to let you know, of course, we will not be answering any questions or entertaining any about this case specifically, so you don't have to worry about that, or the next case for that matter. Also, finally, thank you very much for coming up to Page. And we know it's out of Phoenix, and it's a drive for you if you drove or if you flew, I don't know. But you're welcome because it was a gorgeous drive and a gorgeous area to be in. So I hope you can take a few minutes and look around before you head back to Phoenix. But thank you, because it is important for students to see litigants and frankly to find litigants that we have, two of the best that we have out there. So thank you very much for making the trip.
Thank you for giving us this opportunity.
All right, and we'll just stay and talk among yourselves, as they say, until we get the next